evening. Welcome to the October 21st, 2021 meeting of the Zoning Board of Appeals. This meeting is being held via video teleconferencing pursuant to Chapter 417 of the laws of 2021. And until further notice, all of the board's meetings will be held remotely. So we ask the public to continually check the town's website for updates and new information. There are also options on the website for public comments and to pre-register to speak on public hearings. So please consider that for all future meetings. If you wish to view tonight's live meeting only, please do not join the Zoom meeting and instead go to the town's website. If on the town, please go to the YouTube website and select the CTV Southampton channel. If you wish to be heard during the meeting but did not pre-register, please go to the town's meeting portal, choose the meeting group from the drop-down on the left, and you will find the information required to join the Zoom meeting. With that, I'd ask that you join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We will be starting this meeting with the public hearings. We have applicants and members of the public standing by via Zoom webinar, which is being moderated by CTV. Charles Certain will mute the speakers until it is their time to give testimony before the board. Please be patient. If you find that you are having difficulties accessing the hearings, please visit the town clerk's meeting portal and click on the instructions link. Also, there are a few public hearings that will not be heard tonight, meaning that they'll be adjourned. So please listen to hear when they will be rescheduled for. A reminder that applicants, agents, and members of the public speaking, other than attorneys, will be sworn in, will state their address for the record, and will offer their testimony as it relates to the application before the board. Board members who must recuse themselves from any application will state so on the record and will be removed from the meeting until the end of the hearing. Unless otherwise stated at the end of each hearing, all of these applications will remain open for written comments for all purposes until November 5th, 2021. Those comments can be addressed to the board secretary, Candace, and sent via email, mail, and/or dropped off at town hall. And with that, I would ask for a motion to approve the minutes of our last meeting.
Motion.
Do we have a second?
Second.
Ms. Burgess.
Aye.
Mr. Kelly.
Aye.
Ms. Kern.
Aye.
Mr. Daly.
Aye.
Chair votes aye. And with that, on to adjournments.
Okay, we have a couple of changes to tonight's agenda. First off, item number 3, application of Kenneth Siff and Nicole Siff, property located at 191 Bridgehampton, Sag Harbor Turnpike in Bridgehampton, tax map 972, lot 36, a re-add for 18th meeting. Moving on to the decision calendar. Following decisions are going to be adjourned to our November 4th meeting. 95 Inlet Road West LLC, tax map 900-176-1-1. Edward Burke Jr. and Patricia Burke, tax map 905-2, lot 17. Application of Kurt Steltenpole, tax map 900-86-1, lot 25. And application of LPD 4 LLC, tax map 900-263-3, lot 33.1. Application of NYC ELEX Real Estate Holdings Development Corp., tax map 900-349-2, lot 24. Application of Scott Slatter, tax map 900-24-1, lot 49. And application of 85 Eastway LLC, tax map 900-233-2, lot 1. Move to adjourn those decisions to our November 4th meeting.
Could you, excuse me, could you please add 1201 Noyak Road LLC to that list?
And,
I did that one. I did that one.
Okay.
Oh, thanks.
Okay.
So we're good?
Yep.
Yes. Do we have a second on the motion?
Second.
Second.
All in favor?
Aye.
Aye.
Opposed? Okay,
Okay.
on to the
Item
agenda.
number 1, application of Frederick and Ann Skopanich, property at 1 Cedar Lane, Hampton Bays, tax map 900, 345, 3, lot 1. Applicant requests relief from Town Code 330-11, residential districts, table of dimensional regulations for an accessory distance from street setback front yard of 32.4 feet, where 70 feet is required for a proposed swimming pool on a non-conforming lot, and any other relief necessary.
Board has jurisdiction. We are looking for Ann. There she is. And
Yep.
Charles, we're also looking to add Brian DeSessa back in. Thank you.
Okay,
You're
and
welcome.
unless you're an attorney, I just have to swear you in.
Okay,
All right, so if you can state your name and address, please.
Ann Skopinich, 1 Cedar Lane, Hampton Bays, New York, 11946.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. If you can tell us about the application.
We want to put a small pool. This is a non-conforming lot, and I didn't want the whole backyard to be pool. So we just want to go a couple of feet, I think it's 3 feet past the side of the garage onto what I guess is the elder side of the property. And we want the pool, it's going to be 12 by 18 feet.
Mhm. Okay. So the only relief that you're requesting is accessory distance from street from 70 feet to 32.4 feet.
Yes, please.
Okay, all right. And it should be noted that this property is burdened by 2 front yards.
Yes.
And so that's, the reason that this is, the relief is really necessary. It's almost centered on the property, the proposed pool. Have you heard from your neighbor, looks like your neighbor to the south, about the application? I think it's, well,
John?
it's a little confusing, on the line, but the neighbor that's on the lot, I guess, on Elder Avenue, just
Behind us.
Yeah.
No,
Yes.
we have not. I know he's in Florida for the winter. I
Okay.
sent him out the form, but he did not respond.
Okay, no problem. And have you heard from any of your other neighbors?
Yes.
Okay.
3 Cedar is fine. 1 Cedar is fine. 2 and 4 are fine, as is 8 Elder, and I think it's 6 Elder. Rob Scott.
Okay. Well, a pool is a common amenity in the neighborhood, I'm pretty sure.
Mhm.
I would imagine other people around you have pools, and
Yes.
you're just looking to have what your neighbors have.
And it's a corner lot, so
Yeah.
there's a challenge there, and
Yep, most definitely.
There is a pool at 8 Elder that is absolutely, I don't even know how it ever happened years ago, but it takes up literally, it's almost up to the fence. There's very little space. It's the whole backyard is all pool. And one of the reasons why we want to move it out a little bit is I don't want my whole backyard or side yard, whatever it is, to be all pool. I have a grandson and we just want to have some lawn area.
Okay. We don't have any building department comments. Any questions from members of the board or Anthony or Katie?
It's a relatively small pool. I don't have an issue with it.
I don't have an issue with it.
neither.
Okay.
I agree. I have an issue.
Okay, is there anyone who is waiting to be heard on Zoom this evening in connection with this application? The application of Skopinich, this is for property located at 1 Cedar Lane, Hampton Bays. If you're waiting to be heard, this would be the time to let us know by raising your hand.
I see no hands.
No hands, okay. All right, so I'm gonna move that we close the public hearing this evening, except for written submissions. The deadline for written submissions is November 5th at end of business, and I will have a decision ready at our November 18th meeting.
Okay, so we come back on the 18th, or do we get notified by mail?
What's gonna happen is on the 18th, it'll be on for decision. And at that time, you don't have to participate in the meeting, but the board hopefully will have a decision ready on the meeting on November 18th. You can also check with our Secretary Candace just to make sure it's on, because if there's any reason for it to be delayed, the decision, she'll know about it. So, but as far as I'm concerned, I think we have everything we need.
Okay, terrific. Thank you
Second.
very much.
Okay, thank you. All right.
Like, how do I get out of here?
Just hit leave.
I'll leave.
this meeting.
Okay. Thank you all very much.
No problem. Thank you and have a good night.
You too.
Do we have a second?
Second.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Ms. Kern,
Aye.
Mr. Kelly,
Aye.
Mr. Sessa,
Aye.
chair votes aye.
Item number 2 on the agenda, application of Adam and Leslie Venacour, property at 48 Straight Path in North Sea, tax map 977-3, 31.1. Applicant requests relief from the file from Town Code 330-11 Residential Districts Table of Dimensional Regulations for a proposed principal front yard setback of 72 feet where 80 feet is required, for a front porch, and a principal rear yard setback of 25 feet where 100 feet is required, for a rear covered patio on a non-conforming lot, and any other relief necessary.
Board
If you're looking
has
Heather Wright.
jurisdiction.
Good evening. Hi, good evening, Mr. Chairman, members of the board. Heather Wright for the applicant, Adam and Leslie Venacour. My address is 30 Main Street, Southampton, New York. As set forth in the public notice, the property address is 48 Straight Path, which is in the R60 zoning district, which requires a minimum lot area of 60,000 square feet and a minimum lot width of 150 feet. This lot is non-conforming to lot area. It's 30,166 square feet, so essentially half the size of the required lot area. It has a single family dwelling with a CO that was issued in February of 2019, and my clients purchased the property in March of 2020. So what we are proposing is a portico in the front of the house, which is 144 square feet, and a proposed covered patio off the back of the house that's 645 square feet. So the variances that are required that we're seeking relief is 72 feet from the front yard setback when 80 feet is required, and 25 feet from the principal rear yard setback when 45 feet is required for the covered patio. I believe the public notice originally had 100 feet, but we have a single and separate abstract which shows that the property was single and separate back to 1972. So I just want to go through, it's our position that the proposed variances meet the elements for this board to grant the requested variances. So first, let's take a look at the character of the neighborhood. I think this is a fairly straightforward application in that, what we're proposing, the covered patio and the portico are pretty standard structures for a residential neighborhood. I would, if I can share my screen in case, let me just share this here. Okay, so the survey that was submitted to the board was a little bit, had a lot going on it. So I thought it would be helpful to highlight for you the two areas where we're requesting the variances. So you can see the covered, the 144 feet covered entry porch. And this is the picture of the front of the house. So the reason for the request is the homeowners have figured out that they need some coverage at the front door in order for guests and for deliveries when they're left there. Right now, there's nothing there. So they need this coverage in the front of the house, and then the proposed covered patio will provide the applicant with some outdoor space off the back of the house. So I think if you look at the survey again, you can see that the home itself is positioned really in the center of the lot. The front of the house meets the 80-foot setback. The back of the house meets exactly the 45-foot setback. So in order for these structures to be constructed here, we need the requested variances. And because the covered patio or is attached to the house, we have to meet that 45-foot setback rather than the 10-foot accessory structure setback. You can see that, I just want to show you this photo. This is what the back of the home looks like. Heavy trees, heavy vegetation. The covered patio is not going to be visible from either the rear yard by the rear yard neighbor or to the side. In fact, the side is labeled on the tax map as a private road, but it's actually a driveway, and that's also heavily vegetated with similar sized arborvitae along both the north and west side of the property. Without the variances, there's no way for the applicant to add it on to the house at all, because the house is centered right. It meets both the rear and front yard setback exactly. And The proposed variances will not have an undesirable impact on the environmental conditions in the neighborhood. And certainly, it was not a self-created difficulty. I mean, this was how the house was built on an undersized lot. And so we believe that the requested variances meet the 5-part test for the board to grant them.
Heather, just had a question for you about one of the measurements on the application on the notice versus on the survey.
Sure.
So I have 100 feet to 25 feet on the application, and then it seems to indicate 24.7 feet on the survey.
No,
Unless I'm missing something.
actually, no, that the survey is survey's a little off, so I can see why that, hold on, let me share the screen again.
Sure.
It's why I highlighted the survey
Okay.
so that you could
As long-
see exactly. Hold on
Yeah,
one second.
as long as the 25 feet is on there. So,
It is.
but I'm-
Yeah.
Where?
No, it's 45 feet. So the 25 feet is the, hold on one second.
It's actually 24.7 feet.
24.7 feet, correct.
Right, right.
Well, that's why I was asking, because it was advertised as 25 feet.
Right.
So I'm just
And
trying to
where's
get
the
clarification.
72? Where's the 72?
Not on the survey, I don't think. The 80 is on the survey, but I don't see 72 on the survey.
Let me pull up, I think it's on the, let me pull. The site plan is much easier to.
Yeah.
We can have it
We
amended.
just want
We
to
can
have
submit,
it clear, that's all.
yeah, we can submit an amended survey to show the exact setback.
Okay.
I think it'll just make it easier for you going forward with the building department, Heather.
I agree.
That way you don't have to come
And
back.
also, Heather, when you're having the survey revised, because I did ask Marge about this, the single and separate and 3/10, 4/10, and she says that those calculations have to go on the survey as well. How
Sure.
you came up with whatever you said it was, not 100, but
45.
45.
45, yeah.
Yeah, the depth, the property is 150 deep, which the 3/10 would give you the 45. And I confirmed that with Marge.
Yeah, but I'm saying they have to put that on the survey.
Sure.
Perfect.
Other than that, my only other question is whether you've heard from any of the neighbors.
I have not.
Okay. All right. Other than that, on this particular application, I didn't have any particular concerns, being that it's an undersized lot and being that these are modest improvements to what's already there. So anyway,
I would agree.
I would agree with you, Adam. I think, in my opinion, it meets the 5-part test. Heather did a good job outlining it. It's refreshing to have someone test the 5-part test before us. So thank you, Heather.
I agree
Okay.
too.
Any other questions from members of the board or Katie or Anthony? Is there anyone from the public who is waiting to be heard in connection with this application, which is the application of the Nilker for property located at 48 Straight Path in North Sea? If you're waiting to be heard on Zoom, this would be the time to let us know by raising your hand.
I see no hands.
Okay. All right, Cornelius, it's yours.
Heather, do you think you can get the survey to us by November 5th, or do you need more time than that?
How about I give it a good try, and then if I can, I'll write a letter, but I'd like to if I can.
Have the option. Sounds
Yep.
good. All right, move to close the public hearing, leaving it open for written submissions until November 5th with a written decision at our November 18th meeting.
Second.
Second.
Mr. Kelly,
Aye.
Mr. DeSessa,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Ms. Kern,
Aye.
Joe Vasai. Thanks so much for being here, Heather. Have a good rest of your night.
You too. Thank you all.
Thank you.
Good night.
Item number 4 on the agenda, application of Stephen Shoemate, property at 71 Harbor Drive, Sag Harbor, tax map 900-93, lot 37, applicant requests relief following provisions of the town code for a proposed 2-story dwelling. 1, 330-84D pyramid height for an encroachment in the amount of 2,800 plus or minus cubic feet on the side of the dwelling. And 2, 330-11 residence districts of table dimensional regulations for a proposed principal rear yard setback 27.5 feet plus or minus where 30 feet is required.
Board has jurisdiction.
Good evening, Susanna. How are you?
I'm good. How are you?
I'm doing okay. Just need to swear you in. You can state your name and address.
Susanna Herman and Consultants, 1319 North Sea Road, Southampton.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Can you tell us about the application?
Okay, let me go ahead and share my screen if that's okay.
Yep.
Okay, can we see that? All right, so there's an existing house at the site, and we are demolishing the existing house and reconstructing within the same footprint, with the exception of a very small increase within the footprint. The back of the house is currently porch and decking, and part of that will be incorporated into the footprint of the house. And the other part over on the western side will be porch and deck over here. The property is 14,540 square feet. It's in an R10 zoning district, so it's conforming with respect to lot area. However, as you can see, it has wetlands along two sides of the property, and it's extremely constrained because of that. The existing house is 12.5 feet from the eastern property line, and we're maintaining that setback, which is conforming. But because of the wetlands to the north and to the west, we are pushed into this corner. In addition, this existing swimming pool is to remain. It's going to be refurbished, but the existing pool will stay in its current location. And the new IA sanitary system will take up the whole front yard. So we are building in the only location where we can build, and within the same footprint. We just received a conditional conservation board wetlands approval, a resolution of conditional approval on the 13th. They've required a 20-foot buffer, which is going to be planted heavily with native vegetation, which will actually provide a lot of screening. There's actually a lot of trees and bayberry bushes that are going to be proposed in there. There's a lot of screening existing along the road, which I can probably show you best through photos. That's the existing house from the street. This is the rear of the existing house. As I mentioned, we're building within the same footprint, but this deck and porch is going to come to the opposite side of the house, which will be farther away from the closest neighbor. I've spoken to the neighbor to the east. He's very happy to hear that we're moving this deck over. And he did provide a letter in support, which I provided a copy of earlier today. We have letters from the neighbors on both sides in support of the application. This is a view from the dock looking back towards the house from the water. There'll be more bayberry here, so it won't have a visual impact from the road or from the water. This is the view from the street on the western side of the property. Everything that's not the driveway is heavily vegetated. This is a mix of privet and rose of Sharon that's cut into a hedge. So it's very well screened there, and along the joint property line, which I don't have a great picture of, but between these two houses, the most impacted neighbor is to the east here. There's mature vegetation there as well, which will be retained. So we're actually requesting 3,200 cubic feet of relief. The initial applications at 2,800. We submitted revised plans a couple of weeks ago. The reason for the additional requested relief is because we need to get the footings of the house out of groundwater. So the initial application was for 2,800, and now we're requesting 3,200 cubic feet. It was actually done in error. This is the proper way to do it, to get the footings out of groundwater.
How high up is the house coming, Susanna?
I'm sorry?
How high up is the new house coming?
The total height is 28 feet, 4 inches. So,
And just so everyone knows, I am watching. My internet's having an issue, so it keeps freezing, so my video's off. But I'm looking at this, and what are the floor heights?
okay, so
Floor to ceiling heights, rather.
floor to ceiling heights on the first floor is 8'10". And on the second floor, let me pull up those plans because it's not.
I couldn't find it.
Yeah. It's not on the drawing, but I spoke with the architect and I have those numbers for you. And I believe they're watching the webinar. If you have any questions for them, we can, it's Dave and Don Harvey. If you see them, if we have questions for them, we can bring them in. So let's see, that's not the page I want. Oops. So on the second floor, it's not a straight height. It does, the height of the ceiling goes from 6'3" over on the side because you have the sloped roof, 6'3" here. The flat portion here is 9'4" And there is a cathedral ceiling, excuse me, in the main upstairs bedroom. And the maximum height of the peak of the cathedral is 13 feet. But again, that's only for that one peak of that one room. The main portion of the second floor, the flat part here is 9'4".
Okay. No, they're reasonable heights. That's what I wanted for the record, because as
Yeah.
you know, I always ask that question, and we're not looking
Yes.
for like tens and tens, and
No,
they're doing anything we can to minimize the pyramid here. It's not a lot of relief, but we always look to see whatever we can do to grant the least amount of relief.
right. We've already been through that exercise. And I know that one of the criteria, one of your 5-point tests is, are you requesting the minimum relief necessary? And I think we clearly passed that. It's not a large house. The footprint is only 1,500 and change. 1,567 square feet is the footprint. As I mentioned, the total height is only 28 feet, 4 inches. It's in the same footprint as the existing house. There's really no way to move it over. There's no way to reduce it without significantly altering the proposed architecture. I think it's very reasonable. It's a modest sized house. It's appropriate for the neighborhood. There are 4 other pyramid variances that have been issued within the last couple years on this street. I submitted copies of those earlier. And let's see.
And it's burdened by wetlands. So
It is very
of course.
burdened by wetlands.
that's right. So if you were for the wetlands, I suspect you could find a way to, not, requesting relief, but you have severe limitations on this lot.
No, and we've
Right.
granted a bunch of relief in that cul-de-sac. So I think it was done very well.
All right, thank you. I did submit copies of those. I won't go through all the numbers and bore you, but there's 2 right here at the end of the cul-de-sac that had pyramid relief. The property adjacent to the west received pyramid relief, and then a few doors down, the Frank property at 41. So I think it's definitely within the character of the neighborhood. There's no physical or environmental impact. We're putting in an IA system, we're putting in drainage. We have satisfied the conservation board with our mitigation. This is 41. Just to give you some character, that's number 81 Harbor Drive. That's number 86 Harbor Drive. These are just examples of other pyramid relief that you've issued in the neighborhood.
Okay.
So, and I have letters from the neighbors. From the Newen House family to the west and from Mr. Durazio to the east. They've written letters in support of the application.
All right. We did have building department comments. Susanna, have you seen them?
I have, and I've spoken with Marjorie multiple times. I've gone over the memo and I think I've satisfied every question that she had on the memo. The additional variance that we missed in the initial application is the setback to this covered entry right here.
Mhm.
Only a very small portion of that is roofed. If it weren't roofed, it would not require a variance. The house itself meets the 30-foot setback, but this little covered entry protrudes toward the road just a little bit, and we're asking for relief to go to 27.5. So 2.5 feet of relief is required or requested for the covered entry.
Okay. Just noticing that proposed gate on the I guess south. It's
Right here.
yeah.
Yeah, the existing gate and the existing fence are actually beyond the property.
That's what I was going to say.
And those are all, it's shown, it's probably, there's a lot going on this survey, but we are proposing to remove all the gates that are beyond, all the gates and fences that are beyond the property line and move it to the property line and landward of the buffer. So the new fence will go along the property line, along the landward edge of the buffer, and then along the front property line. So that will be brought into conformance. This gate here is to be removed, the one that's down in the public right of way, and the proposed gate is on the property line.
Okay. Katie, do you think we need to revise the survey? How we could do with that? That the
For the
gate.
gates and everything?
Yeah.
It's shown.
Well, I'm starting to see if it says to be removed.
Well, existing gate fence to be removed.
Yeah, it's there. See it,
It's
see it,
there.
Adam, to the left?
Side.
On the left. I see.
Yeah.
Okay, good. Okay.
It's also a condition of the wetlands permit that be removed.
Okay. All right. Any other questions from members of the board or Katie or Anthony? Oh, by the way, Anthony, thanks for joining us.
Thanks, Adam.
No problem. Is there anyone from the public who is waiting to be heard on Zoom this evening in connection with the application of Shoemake? This is for property located at 71 Harbor Drive in Sag Harbor. If you're waiting to be heard on Zoom, this would be the time to let us know by raising your hand.
No hands.
Okay. If not, Mike, it is yours.
Okay, so are we expecting anything back from Suzanne, or I think we have everything in order, do we? Yeah. So Suzanne, we will leave this open for written submissions until November 5th and expect to have a decision for our meeting on November 18th.
Second.
Mr. Daly,
Aye.
Mr. Kelly,
Aye.
Ms. Kern,
Aye.
Ms. Burgess,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye. Thank you for being here, Susanna. Have a good rest of your night.
Thank you, you too. Good night, guys.
Take care. Good night.
Item number 5 on the agenda, Raymond Julie Lofstad. Property located at 177 B Spring Road in Hampton Bays, tax map 900-235, lot 7.3. Applicant requests relief from the following provisions of the town code. For one, a proposed swimming pool, 330-11 residential districts table of regulations for an accessory front yard setback of 21 feet where 50 feet is required. And 2, 330-76B placement of accessory buildings, structures, and uses in all districts. And 330-83C yards to allow the proposed swimming pool to be located within the required front yard of the principal building. 2, to legalize a second-story deck on the detached garage. 330-11 residential districts table of dimensional regulations for an accessory rear yard setback of 12 feet plus or minus where 20 feet is required on a non-conforming lot and any other relief.
Or
I'm
has
trying to let
jurisdiction?
in Carl.
Okay, we're looking
Okay.
for Carl and maybe Julie or Raymond.
I'm trying to get Carl in, but he keeps denying.
We don't want him in.
Oh, there he is. Who's down here?
Okay.
Good evening, everybody.
Good evening, Carl.
Good to
Boy,
see you
Hey,
all.
Carl.
Hi, Carl.
Hi, Helen, how are you? So as mentioned, this is a application for three specific types of relief. The first is for the inclusion of an accessory structure in a front yard, that being a proposed pool. For the inclusion of an accessory structure and that pool within front yard setbacks. And then again, legalization of the garage in the back of the deck, and the deck in the back of the yard. A few things to note about the history of this property. This property was originally one lot with the lot in front of it. That mother lot was divided into two in 1999 by subdivision. And that subdivision required a variance from this board for lot width. As a result, these two lots exist. And they are exist by virtue of that variance, and as a result, they are have limited lot width. Where 120 is required, they have 100 feet in lot width. So that creates some difficulties in improvement with respect to the lot. The placement of the pool. Let's start with the pool first. First off, the pool is, although it's 21 feet from the front yard setback, or from the front yard line, I would note that as this is a flag lot, you are actually 210 feet from Springville Road. The lot most affected, that in front, remains in the Lofstead family. As I noted, it was one family lot that was divided into two. And certainly they are supportive of this variance for reasons maybe they'll get to use the pool. The accessory structure is, we're asking for relief of from 50 feet, which is required in an R20 zone, which this is, to 21 feet. So it's a substantial variance, but there is support for it, not only amongst neighbors, but amongst recent decisions in the area, and I'll get to that in a moment. Similarly, other decisions in the area have allowed accessory structures in these required front yards. If you go within a radius of 500 feet around, you'll see approximately 10 other pools. So pools are very common in the area. This certainly wouldn't change dramatically the character of the area. The lot is burdened, as I mentioned. There's limited lot width. There are existing structures which have approvals. You might think that the pool could go in the backyard, but the backyard has both the garage and septic, which severely limits the ability to put a pool in there. And I would note that the pool is of modest size and complies with all other setbacks. I just want to discuss some other variances in the area. Decision number 8831 that was issued in 1990, right around the corner. Although this was actually in an R40 zone when the current property is in an R21. It was given at the 7 Harbor Road, right, again, like I said, right around the corner, and permitted the construction of a tennis court 30.5 feet from the front lot line, which was actually a front yard setback. So where 70 feet is required, 30 was provided for this tennis court. That decision, again, 8831 on July 6th of 1990. Right in the neighborhood at 121 Springville Road, decision D013062. This board granted relief allowing for an accessory apartment to be in a front yard. And it also gave relief for both setback and the positioning of it in the front yard. So from 50 feet to 18 feet was permitted for this accessory apartment. And again, allowed for the accessory structure to be in the front yard. And then finally, if you bear with me one moment, at 6 Hampton Harbor Lane, which is again in the neighborhood down the road, there was relief granted in 1990. That decision was the variance decision. Let me just hold up. 9003 on October 19th, 1990, granted for a pool permission to construct the pool 22 feet when 50 is required. Again, that was in a R40 again, so it's a more restrictive zoning district. So there's plenty of examples in the area of similar variances granted. With respect to the backyard, that's an existing structure, that shed. We are asking for relief, as noted, from the required 20 to 12, the setback, roughly a 40% relief. That has been existing for some time. We have no known knowledge of any complaints from the neighbors. Again, I think that the relief is reasonable given the constraints on the yard, given the history of this property, given the character of the community, and given the other variances granted in the region, in the area. For time.
So Carl, wanted to ask you about the legalizing of the second story deck.
Yes.
That is how it was built without permits.
I don't know exactly how. I know the garage was built with permits. I'm not sure exactly how the second story deck got permitted, but we are here now to legalize it. Yeah.
How many years has it been?
Sorry?
About how many years has it been there, would you say?
If you can bear with me a second.
And if you know, Carl, who built it?
I don't know who built it.
Well, I think we'd like to know.
Okay.
My guess is it was a contractor who did it, who probably, built it without permits, but we should have information on the file about that. And as you know, we often ask people to come in with as-built. So, but at a minimum, I would want to have some information.
I would know.
Carl knows. He's here enough.
Was there a, do you have the revised survey? There was a freezer and a shed that were removed. And I just want to make sure that the board has the revised survey.
I don't
Located
see it.
adjacent to the garage.
Yeah, my
do
survey.
have the revised survey.
Yeah.
Sorry?
Do you have the revised survey, Adam?
I don't.
Okay, we have it. We'll see.
We just have the original.
Yeah. So
Additionally,
get to
the
it.
secretary required that we look into whether pyramid relief is required. That analysis is outstanding, so we will provide that as soon as it's available. I did discuss that with Lydia for tonight's hearing.
Okay.
Is the setback, I couldn't find the 12 plus or minus 12 foot setback. Where is that?
Not there.
It is there. If you look in the survey, it says 20 to the structure. It does not actually do it to the deck, but it's that second story deck is 12 foot. So we can update the survey with that as well.
Yeah, we just need the measurement on there.
Sure.
Okay. We also had comments from the building department. Carl, I don't know if you already saw them.
We did see them, and we are in the process of addressing them more. One was the removal of that freezer and the shed, which has already been addressed. And then with respect to the pyramid, that analysis is being undertaken.
Okay. Okay.
So I don't know if you want to keep the hearing open for that analysis, or if you'd like to close subject to written submission.
Well, I mean, I think if it turns out that you need
pyramid
relief, obviously you have to have that.
Yeah.
But otherwise, I don't really see a reason for you to have to do that.
Okay.
At least speaking for myself.
Adam, what your point being that if they don't need pyramid relief, you don't have to keep it open, but if they do, they would come back,
Correct.
re-advertise.
Well, I mean, if it turned out we either re-advertise or just reopen about
Right,
it, depending
okay.
on how much pyramid relief it is. I mean, if it's a minuscule amount of pyramid relief, maybe we just reopen. If it's a significant number, then we would need to re-advertise. But in any case, that's how we handle it. But so Carl, if you're comfortable doing it that way, we can just close it with written subs as if you don't need pyramid, and then let Candace know and Katie know if it turns out you do.
Certainly. Yeah, I think that's the best way to proceed.
Yeah.
Are you considering a special number, Adam? So I mean, if they said 100 feet, is that going to be sufficient for me to just have written subs and not have them have to come back? Can we?
No, no. If it turns out that they need any pyramid relief, they have to come back.
Any number, what, 10?
Any number, what it is, because we just had a public hearing
Well,
without
still,
including it. So
Yeah.
the neighbors haven't been notified that they're requesting pyramid relief. So we absolutely would have to have another date if it turns out they need any pyramid relief. To give the neighbors an opportunity to be notified and express their point of view.
All right, so that's slightly different than what you said before. So if it requires any pyramid relief, they have to come back.
Yeah,
Not just a minimal.
No. What I was talking about is how they come back. Okay, I was talking about whether we reopen it or whether we have them re-advertise.
Okay, got it.
That's what I was
Okay.
referring
Okay.
to. No, any pyramid relief, they have to come back without a doubt.
Okay.
So if they have to come back, then we have to keep the hearing open. Is that what you're saying?
Well, I'm saying we will close it, and if it turns out that Carl sends us a letter saying it turns out the applicant needs pyramid relief, then we make a motion and we vote to reopen. And continue the public hearing. We'll close it tonight, but then we'll reopen it if that happens.
Got it.
I agree with that.
Okay,
I
got
agree
it.
as well.
I mean, there is the, all other relief deemed necessary, but you would want to reopen the hearing.
Oh, I
Yes.
definitely would. No. If you-
Katie, would that
we're-
require renoticing in your opinion?
It's going to be, it really depends on how much pyramid relief we're talking about. I personally, I think it should be renoticed if it turns out you need pyramid relief. Because otherwise the neighbors aren't notified.
So then maybe it makes
I
sense
think you
to keep it open.
Go ahead.
We could do that.
So what if we keep it open, and if there is no relief required, I could submit something in writing saying that we don't need to, I guess you'd still have to open it. We
You
just
still-
open
yeah.
and close it, yeah.
Yeah.
It makes the most efficient sense that if we close it, you let us know as soon as you can, whether they need that or not, prior to a decision, and we can make to have it noticed and reopened.
So you'd rather close it and then reopen it, maybe?
Well, I mean, especially, Carl, if you don't think that there's going to be pyramid relief. I mean, if you were pretty sure there was going to be pyramid relief, then I'd say, just leave it open.
Okay, so yeah, then let's close it and we'll reopen it. I mean, worst case scenario, I have to renotice it. It's not the end.
Okay.
Right.
All right.
So I'll, if that's a motion, I'll second it.
Okay, well, before we do that, any other questions from members of the board? Is there?
Did you, Adam?
Katie? Yes.
Nope.
Adam, did you ask for information on the building of the deck?
I did,
and
yes.
when?
I did. Information on how the second story deck on detached garage was built without permits. I asked for information on
I'll
that.
get the date it was built, the nature of the build, and the cost to remove it. I'll provide.
Okay, all right.
Perfect.
Excellent.
And you want that in written format? You don't want that in?
That's up to the board.
I'm okay.
That could be part of the written sub.
I'm fine with it being.
I have to make a written submission anyway, so I can just include that as part of that.
That would be fine with me.
Okay.
Fine with me as well.
Okay.
I'm okay
So,
with that.
so next, I wanted to ask if there's anyone from the public who is waiting to be heard on Zoom this evening in connection with the application of Lofsted. This is for property located at 177B Springville Road in Hampton Bays. If you are waiting to be heard on Zoom, this would be the time to let us know by raising your hand.
Mr. Chairman, no
Yes.
hand.
No hands. Okay. All right. That means, Helen, it is yours.
Well, as we've said already, we're closing the public hearing.
Yep.
Have some written submissions from Carl by November 5th. And from there, we'll have to see what that is. I can't really say we'll have a decision on the 18th because we may decide to reopen and re-advertise and deal with the issue after it's re-advertised.
Yeah. Well, we're going to put it down for a decision on November 18th. And if it turns out that we need pyramid relief, then we'll reopen.
Okay, I mean, that doesn't make sense to me, but if that's what you like, that's okay.
What would you like? You want to keep it open?
I said I couldn't put it down for a decision until Carl tells us what he has found when he's done his survey. So, but I can accept that we should write it down for a written decision on the 8th. I'll accept that.
Okay.
Are you happy with that, Carl?
You're happy, I'm happy, Helen.
Thank you, Carl. Your presentation was excellent, Carl. Absolutely excellent.
I'd be happy for a tie, Carl.
Yeah, I'm sorry. And the 5-part test, I didn't recite the
Oh,
5.
Brian.
No ties needed.
Where's your tie, Brian?
Where's your shirt, Brian?
All right, do we have a second on the motion?
Second.
Okay.
Thank you all.
You're welcome. Ms. Burgess,
Aye.
Ms. Kern,
Aye.
Mr. Kelly,
Aye.
Mr. Daly,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye. Thank you for being here, Carl. Have a good rest of your night.
You too, guys. Thank you very much.
Right. Item number 6 on the agenda, Jeffrey and Kara Klein, property at 527 Barter Lane in Bridgehampton, tax map 952-1, lot 2.1. Applicant requests relief from the following provisions of the town code to legalize a basketball court constructed without the benefit of a building permit, 330-11. Residential districts table of dimensional regulations for an accessory side yard setback of 11.3 feet where 20 feet is required, and 2, 330-76D, placement of accessory buildings, structures, and uses in all districts, and 330-83C, yards, to allow the basketball court to remain within the required minimum side yard and the total side yard of the principal building on a non-conforming lot, and any other relief necessary.
The board has jurisdiction.
Evening.
Good evening.
Richard, unless you're an attorney, I have to swear you in.
Okay, that's fine.
Okay, if you could just raise your right hand and you state your name and address for the record, please.
Yes, my name is Richard Warden. And my address is 296 McGee Street, Southampton, New York.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can tell us about the application.
Okay, yes. Basically, I'm the expediting agent for Jeffrey Klein and Kara Klein as the owners. And this is basically one point for the variance regarding the setback overreach. And as it was mentioned, it's a 20-foot setback, but it was encroached 700 square feet over the setback limits. And there are 4 points, I think, in support of the variance. Number 1, there's a large privet hedge separating the neighbor's property and the court is not visible. Number 2, the court is made from poured concrete that can't be relocated easily. Number 3, because the court's made from poured concrete that can't be relocated, it's an environmental waste to demolish it and rebuild for that reason. And number 4, the owner has spoken with the adjoining neighbors and no one's apparently opposed to this variance request as far as we understand it at the moment.
Okay. Well, what I want to mention is that the basketball court was put there without permits. And some people get confused with something like basketball court, and I can understand why. I mean, I don't know whether I'm hoping that you talk with the applicants and tell me, talk with the applicants and you can tell me, what the circumstances were. But we've had other applications where there have been sports courts of different kinds where people didn't think they needed permits for them.
I believe that's the case, that they weren't aware that this type of item would require a permit.
I also just want to mention in terms of the basketball court, another thing that although I'm not looking to do this in any way, a cost estimate as to what it would cost to remove it or move it to a conforming location would be helpful to the applicants, so we can see the financial impact it would have on them to have to relocate this court. Presuming they can even find a conforming location to relocate the court.
Right, so you're interested in a contractor's proposal?
And that's just an estimate, yeah, an estimate.
Okay, all right.
So,
Okay.
When did your clients purchase the property?
I'm not sure when they purchased it, but this court was constructed 9 years ago. And basically, let me see here. I'm sorry, 8 years ago. It was 8 years ago in 2013.
Yeah.
They bought the property in 2012.
Yeah, the deed says 2012. So the current owners purchased, current owners installed the basketball court.
Right.
And so this had come before the board in 2014, and there was no resolution at that time.
Right.
I believe it was withdrawn for potentially various reasons on the applicant's behalf. And I'm just trying to understand what's different now that this may be looked upon.
Well, there was a letter written by one of his adjoining neighbors opposing the variance, and basically that neighbor has since moved away, and there's a different neighbor who has told the present owner that they don't object to this basketball court or this variance. So
I just been now 7 years. They haven't legalized it or otherwise, and what kind of message that may send to people that have done things illegally, that if they wait long enough, maybe conditions change. I'm just concerned with that as to this application.
right. Well, that was the neighbor's name was Kathleen Boyers, and she had written a letter and objected to it, but she was complaining about the situation, but like I said, she had moved away, and none of the other neighbors are presently opposed to it. So the new owner of that.
Are you saying because that she's only recently moved away, and that's why it's been so many years? Once she moved away, you had another neighbor who was positive, and that's what made you want to make the application again? Is that what you're saying?
No, that's not what I'm saying. I'm just
What are
saying
you?
that that's one of the points, is that there's no one objecting. I think that
Mr. DeSessa said, and you tell me if I'm wrong, did you wait 7 years before you brought this matter again?
well, I believe because the owner, he does want to improve the property, and he wants to have everything legal, and it's required to have everything legal before he can improve the property on the interior and also on the exterior. And so this is a normal step to overcome this violation. It has to be overcome somehow. Either it's going to be ripped out, or it's going to be just approved. So either way, it has to be dealt with. But he wants, like I said, the main motivation is he wants to do other things in the house, and he can't do that without this situation.
Did you try to find a conforming location that would have made the owner happy?
No, I personally believe that's environmentally not the best solution to rip it out and just move it.
No, but I mean, before Mr. Grossman asked you that if you could find the conforming location, and I didn't know whether you had looked in that area.
You mean Klein, the owner?
Yeah, well, his architect, once he must have at some point knew that it was, he'd need a variance for it before he built it.
Right, he knew that he would need either a variance. Yeah, I mean, obviously, if the variance is not approved, it's going to have to be ripped out, either one of the two.
Well, so now that's not necessarily true, because as Mr. Grossman asked you to, or told you, you can get a report from an architect or a pool man, what it would cost.
Right.
To do that. And maybe that sum is so prohibitive that goes into consideration when we make the final analysis as to whether or not the variance is given.
That's fair. If you want to adjourn, I can obtain that, an estimate.
Yeah, get the estimate and come back
Okay,
and see where we are.
all right.
I
Sounds
did
good.
go to the property and in fairness, there is a very heavy vegetation. It's very protected in terms of that, in terms of, being able to be seen from the road, probably from the neighbors. I couldn't really tell, but it's a heavy vegetation.
And I mentioned earlier on about how sometimes in sports courts, people don't realize they need variances. Well, anybody watching tonight, or approvals, I should say, if you're going to put up a structure, you need to, when in doubt, check with the building department.
Right.
I agree.
Because otherwise you're going to be in a situation like this. It's not an easy thing to have to deal with all of this, I'm sure, for the
At
applicant.
least it's not unsafe, like a basement done without a permit that has no egress. That's the one thing that's not,
Yeah. But I also can understand, because the basketball court is, closed fairly well. I mean, look, we're talking about a difference of 20 feet to 11.3 feet. So we're talking about, less than 9 feet difference. But still, basketball courts, when they're used, are very noisy. And so I can understand that as being a reason why a neighbor would be concerned. But in any case, so I guess the other question is when you'd like to come back.
I could probably have an estimate within a week or so, maybe a week and a half.
Mike, you were going to say something?
Yeah, were you going to ask for other comments?
Sure.
After he was
Sure.
the answer to this, okay. I'm not in favor of this tennis court, basketball court relief at all, especially in a normal day. In a residential neighborhood like this, a basketball court 11.3 feet away from a property line, I'm just not in favor of it. And then take the consideration of the history of this, where it was not going to be approved 7 years ago. So they withdrew their application and have continued to use it for 8 years, knowing that it's not permitted and that it's illegal, And now, because the objector moves away, they're coming back only because there's other things that need to be done. I'm not going to support relief for this basketball court, regardless of any information on how much it costs to remove it or anything. I don't think it belongs there. That's my input.
Okay. Well, I also think it would be helpful for us to hear the public hearing from the last, what occurred at the last public hearing, what our board said, because we may have been very critical of this application then. I don't know.
Yeah.
And that may be the reason it was withdrawn. We have many applications to get withdrawn when we make very clear we're not happy with proposed relief. So I for one, would like to hear what our prior comments were back at that time.
My
So,
question
you're going
is,
to look for the video?
if Michael objects, no matter what, does that mean that it's never going to go through?
Michael is one out of 7. So you need to
Oh,
get
so
4.
it's a majority vote?
It is a majority vote, but you need 4 votes to get an approval or denial.
Okay, thank you.
Yeah.
I would like to come back.
Yeah.
If there is a conforming location, to have that shown.
Okay, I can do that.
Okay. Any other comments, questions from the board, for Katie, from Anthony? Is there anyone from the public who's waiting to be heard this evening in connection with the application of Klein? This is for property located at 527 Butter Lane in Bridgehampton. If you're waiting to be heard on Zoom, this will be the time to let us know by raising your hand.
No hands, Mr. Chairman.
Okay. If not, Susan, it's yours.
So we are going to adjourn until our next meeting, which is November 4th. At which time you will come back with some information for us on the cost estimates to remove and relocate and find a conforming place for the court if possible. And hopefully we'll have reviewed the last public hearing on this matter by then.
All right, thank you.
Second.
Appreciate it.
Okay. Ms. Kern,
Aye.
Mr. DeSessa,
Aye.
Ms. Burgess,
Aye.
Mr. Kelly,
Aye.
Mr. Daly.
Aye.
Chair votes aye. Thank you so much, Richard. We'll see you on November 4th.
Thank you, Adam. Thank you, everyone.
Thanks. Good night.
Good night.
Okay, next up is item number 7, under re-advertised applications. Application of Grant Warner, Brett and David Moore are the applicants. Property is located at 10 River Avenue in Eastport. Tax map 900, 351-2, lot 23. Applicant appeals the issuance of pre-existing certificate of occupancy number C210111 dated April 12, 2021 for the 2-story, 2-family dwelling with partial unfinished basement, 1-story cottage, 2-story cottage as per survey dated October 8th, 2019 by John Gallagher. Other structures approved by the following certificates: P083976, first floor deck on main dwelling and outdoor shower, replace window and bedroom to egress, and any other relief necessary.
Board has jurisdiction.
Okay, Cornelius Kelly, and I'm recused on this application.
Thank you, Cornelius. All
Okay,
right, we have Mike Walsh.
we do. Good evening, Mike.
Good evening, Mr. Chairman and members of the board. I hope you can hear me clearly.
We can.
Mike.
Good. Hello, Mr. DeCessa. I submitted approximately 8-page memo with a lot of exhibits, and most of what I have to say, I'm just going to basically give you an overview of what's in the papers. I also gave a copy to Mr. Hume, who represents the property owner that's the subject of the appeal. Unlike your other cases tonight, this is an appeal of a building inspector determination in issuing a certificate of occupancy to a property at 10 River Avenue, Eastport. My clients, David and Brett Moore, own the adjoining property right next door at 12 River Avenue in Eastport. And when they learned of the issuance of their certificate of occupancy, they sought to challenge it. We filed a notice of appeal with your board. And you sit as the appellate review board in this particular case to determine whether or not the determination should be upheld and the CO affirmed as written, or whether or not it should be rescinded or amended in some way. So I represent, again, the appellants. The property in issue, when this application was first filed for the certificate of occupancy back at the beginning of this year, contained at that time a primary residence. We'll talk about what was inside in a second. 3 accessory buildings in the rear of the property, consisting of a mobile type trailer that had somehow become permanent over the years, which has now been removed. So the first order of business is to confirm that the trailer is no longer an issue. It's been removed from the site. That's no longer being used for residential purposes. What's left are the main residence, the principal residence on the property, the dwelling, and then 2 accessory buildings in the rear yard of the premises, which are the subject of the certificate of occupancy. When the certificate of occupancy was issued back in April, what was granted was a 2-family dwelling, which is the primary residence on the property, a 2-family dwelling, a 1-story cottage in the rear, and an additional 1-story cottage in the rear. I believe that also has changed.
I think it was a 2-story cottage.
According to this, that's correct. One 1-story cottage and 1 2-story cottage. That is correct.
It's in your affidavit, Michael.
Right. Yeah, it's in the first paragraph. You're correct.
Yes.
So we're dealing with 3 buildings here. The principal dwelling, which is allegedly a 2-family dwelling, and 2 cottages in the rear of the premises that are allegedly used for residential purposes. The first thing we did was we looked at the application that had been made for the certificate of occupancy, and we concluded that the certificate of occupancy is based on 2 affidavits that were submitted in support of the application. When we reviewed those affidavits, one is by Grant Werner. It's dated January 27, 2020. We supplied a copy of it with our papers. And the second one is an affidavit that's 14 years old as of the day the application was made. It was an affidavit that was signed in 2006 by a gentleman by the name of Howard Smith, who is now deceased. And Mr. Werner, in his affidavit, references that second affidavit, that 14-year-old 2006 affidavit, signed by Mr. Smith, as support for his assertion that these buildings, including the two-family residence and the two cottages, the two one-family dwellings, the two cottages, because they're allegedly habitable, have existed there since prior to 1957. Okay. Now, if you look at Howard Smith's affidavit, there is absolutely no detail whatsoever in that affidavit. The property's not described. The buildings are not described. There's no other document attached to it or referenced. There's just a simple statement that the subject property, the two guests house, as the affidavit reads, and a second floor apartment in the main house existed there and were actively and continuously in use since prior to 1957. Now, the problem is that the records on file in the building department and in your town files contradict those affidavits. You don't have to look very far into the town's records to conclude that the statements made in those affidavits are simply not supported by the record. Let me explain why that is. The first thing we looked at is any surveys that were on file with the building department. And the first survey that surfaced was a survey that I have attached to my papers as Exhibit D. And that survey.
Mike, when Mike.
Yeah. I'm sorry.
When did you submit those papers?
We submitted them this afternoon. Yeah.
Oh, I'm sorry.
By
I thought
email.
We don't have it.
We don't have.
I didn't. I got it.
Yeah.
Okay. Sorry.
Yep.
Yeah.
We collected a lot of this stuff very recently. Anyway, there's a survey in the file that you'll have an opportunity to look at. It's dated 1964, and that survey was prepared for the original owners of the property. That is William Werner and his wife Hazel. I believe they're the parents of the present owner, Richard Werner. And that survey is in your file. It's from 1964. It describes a two-story residence and two frame barns in the rear of the property, two frame barns. It does not describe guest house, dwelling, or any accessory buildings in the rear yard besides the frame barn. That survey is guaranteed to a title company, to a bank. And the assumption is when the surveyor went out there, he observed what he observed, and he reduced it to a depiction on a survey. So the only survey that was in the file at the time the new updated CO was issued was that survey, with the exception of the application survey, which was prepared based upon the present facts existing at the site in April 2021. Certainly not an historical survey. The second thing that's in your file, that was in the building inspector's file, I'm not sure if anyone looked at it, was a 1972 building permit application that was made by Hazel Werner when she came to the building inspector right after that 1972 code update was adopted, and sought to legalize one of the frame barns in the rear yard and turn it into a so-called playhouse. In our submission, what you'll see there is a copy of the application that was made in 1972, a copy of the survey that was attached, which was this Wilhelm survey depicting the barns. So we know that when that application was made in 72, that the property was being used, those two accessory buildings were being used as barns in the rear of the property. There's no indication whatsoever in the application in the application that was signed by Mrs. Werner, who I believe is now deceased, or on the survey that there was anything other than 2 frame barns in the rear yard. The building inspector did grant the permit and a certificate of occupancy in 1972 to convert one of the frame barns to what was then called a playhouse. Again, there's no indication that there was any habitable use. There was no cottage. There was no guest house, nor is there any indication whatsoever that the 2-story residence at the site was being used as a 2-family home. There is a lot of emphasis being placed on these assessment records, which I believe are part of your file, and in the form of what we call discard cards that were obtained from the assessor's office. They're also on the GIS as part of the documents on file with the GIS, and that gives a pretty good history as well of the property. The assessors, even when they were using this manual system years ago, they made sufficient notes to give you some indication of what was going on the property. And what we see there is the assessment cards. When you go back to the assessment cards, there are 4 of them. The first one describes a house and land, doesn't describe the accessory structures, doesn't describe the 2-family dwelling. It indicates that Mr. and Mrs. Werner first bought the property in 1964, which is probably where the statement in Mr. Werner's affidavit on this go-round indicates that he's familiar with the property since about 1963, 1964 came from, because his parents bought the property. There's an indication on the next card that a trailer was added. We know there was a trailer, a mobile trailer added in 1964. And then we spoke about the conversion of the playhouse in 1972, the barn into a playhouse in 72. There's a note on the second assessment card, 1973, they picked it up as a playhouse, the assessor. No indication on those cards in the note section that any guest house was added, that there was a 2-family dwelling on the property, or that there were any guest houses on the property whatsoever. Interestingly, in 1976, there appears to have been a note added, GST-HSE, on the card. GST doesn't say that it was added or converted or anything like that. There's just a note, a bare note, HSE-GST-HSE, which we presume stands for guest house. That wasn't added apparently until 1976 or thereabouts. In my memo, I go through the law on the subject. 1957, October 14, 1957, the town adopted its first zoning code. At that time, building permits and certificate of occupancies were required if there was to be a new building or a reconstruction or a conversion of any building, including frame barns or a 1-family residence. And a CO was issued from 1957 through to 1972 if you were to make such changes. None of those documents exist in the building department file, neither an application for a building permit for a conversion or change of use or otherwise, no COs. Same thing from 72 to the date of the issuance of the April 2021 CO that we're complaining about. And it's our contention in this particular appeal that there's just a complete lack of, credible evidence, documentary evidence. You can put whatever label you want on it to warrant the issuance of this April 2021 certificate of occupancy. It's just missing in the file. And we believe unless there can be some proof shown by the applicant and or the prior owners, if they can find such information, there's just nothing here to support the issuance of the certificate of occupancy based upon the rules that the building inspector and your board have operated under for many, many years. Again, everything's writing in my submission. The affidavits simply don't do it because they're factually incorrect as a matter of documentation on file with the town. And that's our case. My clients obviously would prefer to live next to a one-family dwelling. They have a one-family dwelling with a garage, to live next to a 4-unit unpermitted, we believe, illegal multiple dwelling situation is unacceptable to them, respectfully. And we've put that in our papers. I know Mr. Hume was going to attend tonight. I know he was at the another meeting, and you know, we've been cooperating and talking, and you know, we have an open dialogue. I want you to know that that we have been talking, and I've worked with Jim for many years, and we'd like to continue to talk about the situation. But be that as it may, we're prepared to, you know, respond to any questions, submit any more documentation, and respond to anything Mr. Hume may have this evening.
Excuse me, Michael, can I ask you where, Mike, where do your, maybe I missed this, where do your, the applicants here reside? Is it north, south?
Immediately, it's immediately adjacent to the, bear with me. Just let me get my directional on the survey.
To the north.
Immediately north, that's correct. Jim?
So on the other side of the LIRR, or?
Oh, no, they live, no, they adjoin the property. They adjoin the property line where the buildings are, yeah. Yep.
So on this aerial, they live just
Right
below
below, right below the site,
Okay.
correct.
Thank you.
Any other questions of Mr. Walsh?
Mike, what is your position that the property, that the CO should read what? A single family dwelling, a playhouse and a barn?
Correct.
Okay.
All right. Now, if there aren't any other questions, I wanted to ask if Jim, if you could give us your comments.
Sure. Would it be possible to share my screen?
Absolutely.
Thank you. See if I can do this. Oops.
We got it. We can see it.
Okay, now I can't see you. Oh, there you are. Thank you. All right, so my name is Jim Hume from the law offices of Kelly and Hume. I represent Grant Werner, who is the current owner of the subject property. Grant, I believe, is here somewhere as well, and he may have some comments at the end. But I just wanted to step through the evidence that we presented to the building inspector, and which assisted the building inspector in reaching the conclusion that this property was entitled to the certificate of occupancy that the building inspector issued, with one caveat. One of, and we'll come back to this in a little bit, but Mr. Walsh had talked about the conversion to the playhouse. And we, in fact, agree that took place. And the fact that playhouse later became a residence did not legalize that. And had Mr. Walsh not filed this application, we would have already gone back to the building department to ask them to reissue the CO to reflect the fact that the smaller of the rear yard structures, which was in fact converted to a playhouse and has a CO as a playhouse, was in fact that. And at the request of the building department, we removed the cooking facilities from that building. So we were a little bit surprised ourselves when the CO issued with that additional comment. But be that as it may, my client's family acquired the property in the early 60s, 1964. And what I'm showing right now is the survey from that era. And Mr. Werner, who is here, was much younger in those days, but he in fact lived there in those years and for many years after. In 1964, there was a residence in the front, and there were two structures in the back. And as further evidence of that, this is a hard to read aerial from 1962 that I got off the GIS. but you can see, I believe the cottage is here and the house is up in front. And the appellant's property is this property here, just to the north. Railroad tracks are up here. Montauk Highway is up a little bit further.
I'm not
Can you
seeing
scroll it
that in
down?
my,
Yeah,
I'm not
we're not,
seeing it in my
we're not
screen.
seeing the aerial, yeah.
Yeah,
You're
you have
only
to
seeing
move it
the
down.
survey, yeah.
You're still seeing the survey.
Yeah.
All right.
Just
Look at
scroll
the-
it down.
just the sliver of the aerial, that's all. Yeah.
How about now? No?
Nope.
Yeah.
Nope.
How about that aerial?
Nope.
Okay,
Nope.
all right, let me,
Nothing's changed.
okay, well, let me do it this way then.
You can unshare, move it, and then share again.
There we go. Okay. So, stop sharing. Move. And share. And share.
It's
Okay.
always a way.
How about now?
Yep.
Okay, so this is 1962. It's a little hard to see, but if you look carefully enough, you'll see the house in the front and the two barn structures in the back. And then just to get a clearer picture of what existed then, and the changes that occurred. This is a 1976 aerial, and you can see very clearly that the two rear yard structures, the main house, and the addition of the trailer, which was from that point forward used as a residential structure. And again, here to the north is the appellant's property. So let's move on. Again, this is one of the discards, and it identifies as being on the property at some point the trailer, which we saw in the a house and a guest house. It also notes the conversion of a barn to the playhouse. And there's several dates. The last one is 76, but 73 was the conversion. So it's not 100% clear from this document when what we believe is the identification of the guest house was added to the property, but it was in or around the time when multiple residences were still permitted. It was Zone B, I think, in those days. And so that's part of the basis for why we think the one of the rear cottages as a residence was legally existing and should be entitled to the CO that was issued.
But what you just said, Jim, is important. So when do you think that multiple residences were permitted on a structure? Because that typically is not the case.
Up to 1972.
In what zone? In what zone?
The B zone.
All right, so you think up to 1972, multiple residences were permitted in a B zone?
Yes, and in fact, we made that presentation to the building inspector, and as evidenced by the CO issued, he agreed with us. So it's the 1957 date is not overly critical here. It's the 1972 that's the more important date for these purposes.
Did you make that argument to the building inspector like in writing, or did you just have a conversation?
We presented this information to him in a meeting in his office.
Yeah, no, I just the B zone, the B zone multiple residences. I'd like to see something on that.
Okay, I can subsequent to tonight, I can provide that information.
And with those,
And confirm it.
Yes.
Confirm it, because when I'm looking in GIS, it says C zone, which I don't, the letters don't mean anything to me. I'm interested in where
Right.
you think.
Okay, I
multiple
will,
residents.
I'm not prepared to do that now, but
Yep.
if we can keep the record held open afterwards.
And I'd be interested to know as well, because I don't recall
Okay.
that circumstance where it was
Okay.
post 57 multiple residences, but
Mhm.
Yeah. Well, we will find out.
Yes, we will. Yes, we will.
And James,
Um,
was it those two adjoining buildings, they were used as residence at the time?
At the time, not clear, but we're conceding that one of them is not and was not a legal residence under the code, and has subsequent, based on the request from the building department, been neutralized as far as its use as a separate residence. And so,
And that's the Playhouse?
yes, that's the Playhouse.
So you've taken that building and converted it to a playhouse?
Well, no, the building was in 1972 was designated as a playhouse at the request of my client's mother. It subsequent to that came to be used as a residence, and as part of the review process with the building inspector, we agreed with him that we could not prove that that structure was anything other than an accessory structure. And as a result, he asked, and we agreed to remove the kitchen cooking facilities from that building, thereby rendering it purely accessory and not residential. So we're, to put it in another way, the CO that we're looking for, we believe should say the primary residence with an apartment, an accessory building, and a guest cottage is what we would suggest that the CO should read and should have read when issued.
Say that again?
A primary residence with an accessory apartment within, an accessory building, and a guest cottage.
And that original building is still going to be a two-family building?
Yes,
So it's two-family, a cottage, that's three,
yes,
and the two buildings, so it's five residential areas. Is that right?
no, no.
What did I
There's
miss?
there's two residences in the main building and
And
one
the
residence
apart-
in
and
the
the apartment.
rearmost.
And the apartment. So
There
that's-
is, in the building that's right on the street, there is a principal home and an apartment. So in that front building, there are two residences, if you want to look at it that way. Going from west to east, the next building you encounter is the Playhouse, which we have returned to an accessory structure, no longer a residential structure. And then going one structure further west, further east, I'm sorry, is what we believe to be the guest cottage, which is referred to in the various discards, which I'm showing and which I actually submitted through the portal a little while ago today.
So when it says here that the first building, call it the building one, is a two-story, two-family dwelling. That means the building and the cottage. It doesn't mean that the building itself is a two-family building. Is that right?
I'm not sure what you're reading from.
It's a two-family building. The primary residence is a two-family building.
Yes.
And then there's the apartment.
No,
No, the
No.
apartment is considered one of those families.
thank you.
So it's the
That's
primary
not my
residence.
usual understanding of a two-family house. I mean, all the houses that have a house and an apartment, they don't refer to, as I've seen it, they don't refer to their building as a two-family building. It's a building and an apartment.
Okay, well, I'm happy to adopt your language for that building, but those two features are contained in the front building. The second building is just accessory, and the third building is a residence, the guest house. And we believe that the discards that are part of the record demonstrate that. They also demonstrate that the trailer was there prior to 1972 as well, but we voluntarily agreed to remove the trailer from the premises altogether. So there might have been an argument that we could have kept the trailer as some form of residence, but we didn't. We agreed with the building inspector to remove that. So let's see.
Yeah, but I thought, Jim, it was interesting at the beginning that you mentioned how you would have, even without this appeal, you would have gone back in the building inspector to have this CO, revised anyway.
Yes.
It seems to me that whole line of thinking means that there might be an opportunity. I mean, what do I know? But there might be an opportunity for something to be worked out between you and Mr. Walsh and the building department. I mean, based on what is factually correct,
Right.
as to what happened. And
Well,
documented.
I don't really want to talk about the settlement negotiations that we may have engaged in, but Mr. Walsh has been aware since he first broached this appeal that we believed his appeal didn't cause us to believe that the CO is issued was incorrect. We recognized it as incorrect the moment it was issued, but the appeal came up within 30 days as it has to as a matter of law. So we didn't take any further steps with the building department to have that language changed.
Yeah.
But we told him, and we concede here, that the language relative to that middle little accessory building needs to be changed to reflect that it is not a residence, because we agreed that the evidence wasn't there to prove that.
So are you saying that when you got the notification and you saw that there were incorrect facts in it, you could have at that point gone there, have it fixed, and then Mr. Walsh would not have had to get.
No, I'm not saying that at all. I think Mr. Walsh believes, well, I don't want to speak for him, but the mere fact of correcting the CO to what we believe it should have said, I do not believe is sufficient to satisfy Mr. Walsh and his clients. And I think they would have brought this appeal even if the CO were correctly drawn in the manner that I described.
Okay, fair enough.
And as Mr. Walsh indicated, there were a couple of affidavits which generally tend to support the various uses to which the property has been put over a long period of time. Mr. Werner is here, and I would like to have him unmuted to talk about the front house and his experiences with people who may have rented that house during his lifetime when he was living there.
Sure.
So Grant, can you unmute yourself, or does somebody?
Yep.
No.
You need to unmute. We can't hear you.
Can you hear me now?
Can hear you
Yes.
now. So I just had to swear you in. If you can just state your name and address for the record, please.
Grant Werner. My address is 10 River Avenue, Eastport, New York.
And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can now give us your comments.
Thank you for giving me the opportunity to speak to you folks. I don't want to give you a long family history, but I would tell you that my parents were very much blue collar working class people. My father was a cabinet maker. His business failed, and we had some very lean years. And when they found the house in Eastport, they saw that having a house that had some rental income was the only way they could support themselves. My mom was a nurse, but had left her job in order to raise 4 boys. And she was also taking care of an aging grandmother. So I heard my mother say time and time again, they would not be able to make it without those rental incomes. I can tell you specifically growing up in what we called the big house, not that kind of big house, with my 3 brothers and parents. There was always the upstairs apartment was always occupied, and for the longest time, I remember distinctly it was occupied by a Mr. Halsey. Didn't know too much about what he did for work, but I was a 8-year-old kid, and I do remember that he loved hot dogs. And whenever my mother made hot dogs, which was on quite a regular basis in our family, she would always give me 2 to take up to Mr. Halsey, and he would always give me 1. So me being a chubby little 8-year-old kid, I liked that part. I got to get an extra hot dog. So very distinct memories of that upstairs apartment always being occupied. And I also remember my parents scolding us about making too much noise, that we would disturb the tenant upstairs. Yet when I saw Mr. Halsey, he would apologize to me and say, I hope I'm not making too much noise for you boys downstairs. So that's my main memory of that. I don't know too much about this business about assessment cards and the surveys and such, but I can tell you I lived in that house since 1963. And then when I retired last year, I'd worked for Spionk Lumber for almost 40 years, and I decided to sell the home and found out at that time that we needed a C of O. So we went through the whole process, and the town required a number of items to be addressed, which I did. And then Mr. Hume met with the chief building inspector. I can't remember his name right now, but they approved. They were happy with what we had done. And the only exception, which Jim has already gone over, was we believe the incorrect issuance of the C of O for the small cottage. So that's my memories and my recollection of what happened there. Howard Smith was my next door neighbor. That's the fellow that wrote the affidavit. And I just asked him very simply, could you write a little statement about your knowledge about the house? And that's what he gave me. That's how he wrote it. So that's what I gave to Mr. Hume, and I guess that's in the evidence now. So if you have any other questions, I'm happy to answer them. But that's my story in a nutshell.
Dial in on the phone line.
Did the apartment, the apartment in the bigger house, Mike, we can hear you. Did the apartment in the bigger house have like a kitchen upstairs?
Yes. Always had a kitchen. We very rarely went into that apartment. I don't think my mother liked the idea of us going up into the apartment of a single man.
Yeah.
But I do recall that from the get-go, there was a kitchen upstairs.
And there's still a kitchen there now?
Yes.
In terms of the living spaces that are there, Grant, were they, to the best of your recollection, were they continuously used as living space, or were there periods of time when they were vacant?
No, they were continuously in use. My mother depended on the income. Like I said, she was raising 4 boys. My parents split up, so my mother was a single mom, and we had an aging grandmother who lived on the property in the trailer, and that income was vital to her.
Yeah. The only reason I ask about that is about any issues of abandonment of any of the uses. That's all.
No, that was never the case.
Okay.
So right now, what is being occupied?
Nothing.
Nobody.
Everything is vacant except the downstairs apartment in the main house, which I use that for that's my use. But nothing else is occupied because I'm going to hopefully be selling the property, and I wanted everything to be empty. I just thought it would make for an easier sale.
You said you're in the downstairs apartment?
I'm in the downstairs apartment in the main house.
So the apartment that Mr. Halsey was living in was this downstairs apartment?
No, he was in the upstairs apartment.
You know what I mean? The house had 2 apartments?
Yes, there's 2 apartments in the big house, the downstairs and then a smaller one upstairs. That's where Mr. Halsey lived.
He just means there's 2 separate distinct living areas. It doesn't matter if it's a house or an apartment or single house.
The main house, I'm sorry, the main house has 2 separate entrances, and one is for the downstairs and one's for the upstairs apartment.
How long have these spaces been vacant?
I think since, let's see, what month are we in now? October. They've been vacant since approximately May, somewhere in that neighborhood.
So my understanding is that you're trying to sell this property and you're trying to clarify everything, but that you don't look for these residences to be occupied for income for you right now.
Not for me right now, and only because I thought it would be a simpler, I originally planned to put the house on the market in May because we had gotten our C of O, and I figured, okay, we're good to go. And that's why I emptied out all the apartments. And then we had the challenge from the neighbor, and here we are 6 months later. But they had all been occupied continuously up to that point.
And there was no intent to abandon the uses. It seemed we were, as Mr. Werner indicated, he retired and he wanted to move on, and he needed to sell the place. And the decision was made that it would probably be easier to sell to a willing buyer, without him having to take over Mr. Werner's tenants.
Exactly.
I was just going to ask, you feel like the attractiveness of the property is enhanced by having these possibilities for additional rental income? Is it a selling attraction, or is it you don't care?
Jim,
Well,
what
if-
do you
Yeah,
think?
It's really
I
what-
think most definitely it has an impact on the value of the property.
Okay.
And it always has. The fact that it could produce additional income.
Okay.
Any other questions? Mr. Werner?
No questions from me. Thank you.
Okay, it looks like Brett and David Moore are also waiting to be heard. So if you guys can unmute, I will swear you in. You can just state your names and addresses. I'm presuming both of you are going to speak.
David Moore, 12 River Avenue, Eastport, New York.
Okay, and Brett, are you going to speak as well?
Brett Moore, 12 River Avenue, Eastport, New York.
And do you both swear to tell the truth, the whole truth, and nothing but the truth?
We do.
Okay, thank you. You can give us your comments.
So just to go back in time a little bit before we purchased this property, when we were initially looking to buy, one of my biggest concerns was the cottages and the trailer next door. The owner of our home that was selling the home assured us that they were illegal, and he had never made a fuss about it because
Because they were friends.
they were
and
friends.
So,
So-
and the neighbors were quiet, so they let it go. But these were illegal dwellings and there were no rental permits. So then when we purchased the house.
Well, no,
or
no,
what-
no. So we were about to sign the contract, and the Sunday before, we drove by the house, as you would do before you buy a new house, and we saw the for sale sign at Mr. Werner's property. At that time, we went and looked at the Realtor listing, and the Realtor listing said it was a once in a lifetime multi
Income producing
property, and listed it as the main home, the apartment upstairs, the trailer,
And
the
two
playhouse,
cottages.
and the 1.5-story cottage. So they were trying to market this property as potentially five families.
living on it.
Now, all of these buildings border our property line. I mean, I can look out my window
And we
right
can
now
see
and
all of
see
them.
all of them. There's, the 2-story home, the playhouse cottage, and the cottage in the back. So that's how this property was marketed.
And
Wanted
we
somebody
weren't,
to
and we
come
were not
in.
interested in living next to a property that could potentially have all of these different families, the parking
A tenement
situation,
building.
there's not adequate parking
So if
on
you-
the property.
So you could potentially have, how many people could
10,
have living
12,
there? 10?
16.
What's the environmental impact? Was the septic system ever upgraded?
There's,
So, like, make a long story short, we called our realtor and said, forget it, we're not going to contract on this. And we didn't. And a couple months later, the owner of the property, our property, reached out and said that he reported it to the town shut it down, and that those 2 cottages would never be legalized.
the town
The
said
town
this.
said this. So that was one of the biggest reasons for us reconsidering purchasing this property. We love this area. We paid a significant amount to the Peconic Land Trust because we believe in preserving, the area. And come to find out,
Somehow now
basically like in somehow
magically these
April or
COs, right,
April or
are
May, I hear
obtained.
that there's something going on, and I go on the portal and the GIS, and I see that all of a sudden, like due to 2 affidavits, he's issued COs for the accessory apartment, which we all know is never legal, a playhouse. Okay, so it became a playhouse in 1972, but then was like rented, and then a 1.5-story cottage in the back. So, like Mr. Walsh says, it doesn't take too much digging to see that this was always a 2-story, 1-family home with
and
2 barns.
Where did we get from the original survey with that information on it to now having 4 legal dwellings? Where is all of the backup information to show how this came about?
So if this becomes legalized, basically, so if I rob a bank for 20 years, all right, and I don't get caught, but in year 25 I get caught, well,
Okay.
doing it for 25 years, and
I don't know that robbing a bank is necessarily a fair analogy, but let me say
doing
this.
something, not following the rules.
Let me say this, okay? The building department and the building inspector made a determination. This determination has been appealed. The appeal of the determination and this proceeding is looking with fresh eyes about the entire history of what's happened. Okay, so we are not bound one way or another to what the building inspector, the determination of the building inspector. Okay, and it could be, this is not the first time. Many times I, as a board member, and I think many other members of the board have dealt with this. Sometimes during the public hearing on an appeal, we get additional information, information that the building inspector may never have received. So that's part of this process. So I understand, that it's hard, and upsetting to be dealing with all of this. But we're here, I think at this point to gather information. We have 2 attorneys, on this who are apparently communicating with each other, which is always a good thing as far as I'm concerned. But we want to get to where we need to be in terms of what actually happened on this property. You may have information. Mr. Werner may have information. All of it is information what we will consider.
I think you have all the information that you need.
Brett, can I ask you a question? When you refer to these 2 houses as barns, if one were to look at it today, do they look, if you've been close or nearby, do they look habitable or do they not look habitable?
No, of course not. They do not look like barns anymore. They have been.
But do they look like places that somebody could live in?
Oh, absolutely. They have been completely remodeled and converted to livable spaces.
Well, both of them. One of them though is still a playhouse, or is it also a?
Well,
It was being lived in,
up
until
it
we
was a
reported it.
studio apartment with a kitchenette. And
There is a
apparently-
kitchenette in that.
Well, I think the kitchen maybe has been taken out, is what I've heard, to put it back to being a playhouse.
Which, the playhouse
I don't
isn't
know what a
isn't
playhouse
isn't a cottage.
Right.
It's not an apartment. It's it's where your kids can play.
The reason I asked you this is because Grant is sort of, my impression as part of Grant's conversation with us, that he thought it was important in the sale to have these properties so that the new owner can have reap greater profits by being owner of this property. So, I mean, that may not
So
be.
you're gonna say
Maybe
that-
pardon me?
I think that's kind of a mischaracterization of what Mr. Werner indicated. He wanted to sell the property. He, for his lifetime, believed that he had certain uses on that property, but he knew that he needed to get an updated CO in order to properly market the property. We went to the building inspector, we filed the necessary papers, we had meetings with them and presented some of this evidence. And I believe that the building inspector himself did some inspecting and reviewed some records that were available to him that may not have been available to others. And he came to the conclusion that some of the stuff there was legal and some of the stuff there wasn't. He asked us to make certain changes to the property because of that opinion. We did that. We eliminated the kitchen in the one structure. We eliminated the trailer altogether. And he then issued the CO. So
In
it's
error.
not, you know, it's, you just haven't characterized. And Mr. Warner just wanted to find out what he had. And we believed that when we got the CO, that was an indication from the town as to what they believed that we had.
Well,
And we
that's
were-
interesting because before he did all of this to obtain the COs, the listing, we
It was
submitted the
listed,
listing.
it was
as
listed
part of
prior
this.
to
It was
COs being
listed
issued.
in September prior to.
Because
way
since
prior to this.
since the late 60s, early 70s, the property had been used in that way.
But you were trying to sell it
Okay,
to a prospective
okay, but
buyer
this,
without COs.
this
Yeah.
back and forth, no, the back and forth has to stop. Back and forth has to stop.
Yeah, okay. So I appreciate your comments. We are open to accepting any submission, any evidence, any documentation of any kind related to what occurred on this property. So, I just want to mention, all who are involved to know that. Let me see. Before I go back to Mike and Jim, I just want to see if there's anyone else on the public who's waiting to be heard in connection with this application. This is the application. The owner is Werner. The applicant is Moore. This is property located at 10 River Avenue in Eastport. Is there anyone else who is waiting to be heard on Zoom? If you are waiting to be heard, this would be the time to let us know by raising your hand.
There are no hands.
No hands. Okay. All right, then Mike and Jim, I don't know which one of you wants to go first. Also, I don't know whether Grant also wants to say a few more words. I'm going to leave it up to you.
Do I have to waive? Do I have to waive?
No, we hear you.
No, we hear you.
Okay. Yeah, I mean, I've heard some new information this evening, which I would like to discuss with my clients. We also have some further information that we have not yet presented to the board when we talk about, for example, the present state of the property. We've got some very nice real estate listing photographs, which we'd like to submit to the record. And I think it'll better inform the board as to the condition of the inside of the property today. And we all understand the way things worked in the old days. And we appreciate the fact that Mr. and Mrs. Warner, bless their hearts, were able to, use this property, in some fashion to, assist their family in growing, as it were, and moving on. We understand all of that. The problem we have is when these units are occupied without permits, without approvals, without any indication when, how, where, what the configuration was. That does not add up to a very valuable document, which is called a certificate of occupancy. My clients, as they indicated, when they first came to this problem, they saw a listing that was advertised in this property with essentially 1, 2, 3, 4, 5 different one-family dwellings. And there's no way, looking at this record, that 5 dwelling units or 4 dwelling units or 3 dwelling units have been properly proven to have been pre-existing non-conforming. And by the way, we will answer that question about the 1957 code. The question is, no, multiple dwellings were not permitted in 1957. They were not permitted in 1972, either in the A, B, or C zones. And we'll brief that for your board, make sure that's part of the record. We'd like to regroup. I'd like to have a discussion with my clients and Mr. Hume. He's always been very professional. We've always had an open dialogue on these type of matters, one way or another, and we'd like to continue that discussion. I would suggest to the board, if you're free, it sounded to me when you first discussed your agenda, I was one of those voyeurs that was listening to your initial discussions about your calendar and eavesdropping. And you mentioned that in December 2, I think it was wide open. That would be a good date for me. Obviously, subject to Mr. Hume's scheduling and anyone else's that's interested in the matter. But
That would be fine.
My request this evening.
That would be fine. I would join that request, Mr. Chairman. Thank you.
Okay, okay. All right. Let me see. So Brian, you have the lead on this one. Is Brian still on?
Yes.
I wanted to say one more thing. For the next hearing. I would also like any kind of, who represents the property, Jim, anything that you might be able to put together too on, the size of these structures. Because again, like Adam said, the board is hearing this for the first time, as a case of de novo, it's fresh eyes,
Right.
they're making the determination. If and when the board even thinks that maybe parts of these are pre-existing and are entitled to COs, any new construction, any expansion has got to be legalized as well. And I think it's interesting on the one survey that Mr. Walsh was talking about with, one-story barns, or even more recently, there's this, the survey that talks about both of the cottages being one story. The new updated CO refers to one as 2 stories. So, was it always 2 stories, or did they, build a second story? Because that would count towards an expansion. So any kind of historic documents that might talk about the square footage, I think is going to be helpful as well.
Okay, we can do that.
So I'm going to make a motion that we keep this open for all purposes and carry it over to December 2nd.
Second.
Mr. DeSessa,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Ms. Kern.
Aye.
Chair votes aye, and Mr. Kelly had recused himself, so he abstains. Thank you all for your comments this evening. Have a good
Thank you
rest of
very
your
much.
night.
Thank you. Be well.
You
In
too.
December.
Yep.
All right, Charles, we got to bring Cornelius back in. There he is.
I'm back. Okay. We're all set. Moving on.
Yes.
Yep.
Number 8 on the agenda, Huckleberry Lane East LLC, property located at 11 Huckleberry Lane East, Hampton Bays, tax map 900-231-1, lot 21. Applicant request relief from the following provisions of
Nope,
the.
this is a holdover.
Oh,
a holdover.
don't need to read it. Thank you.
Nope. So we just have Jet.
Yes. Hi, Jack. We just, you're muted. There you go.
Good evening. How you guys doing?
Doing well. I'm pretty sure I had sworn you in last time.
Yes.
Okay, so if you can just give us an update as to where we are.
So as per the board's recommendations, we have revised the survey and I've sent that in. I don't know if you guys have it in front of you. We've been working with our surveyor trying to get the setback as far away from the property line as possible. If you see in the survey, we have managed to get it to 15 feet from the property line, from the initial 5 that we were requesting. And this was the furthest that we can get, without actually having to demolish the deck that's already there.
Does everybody have the survey? Or you want me to try to share it?
I have it,
Yeah,
but if you want to
Try to
share it
bring it up.
anyway, feel free.
You can
I
share
got
it.
it. I
Yeah.
was practicing before, so
Okay.
gotta move this.
Move it
Oh no,
down.
what have I done? Trying to figure out how to move it down. Because I have you guys on my screen.
I can see it pretty well. We have it.
I got it.
There we go.
There we go.
Mm-hmm.
Okay.
Go
All
ahead,
right.
Jet.
Okay, so as you can see, we have moved the pool to have a setback of 15 feet from the property line. And also there was a note from the building department last time that the one part of the house was mislabeled and it was just reading 2-car garage. And now it's corrected to say 2-car garage and 2-story.
Okay.
Okay.
So I believe we had asked that the pool be moved. It has been moved. I can't see how much further it could be moved, being that the wood deck is, on the other side. So the question is whether we're good with the new location.
I am.
I'm comfortable with it. I think it's
I'm
a big improvement. 15 feet, and that's 15 feet at its closest point. It looks like it could be 20 feet at the other corner. So I'm comfortable with it.
Me too.
I am also.
Okay, excellent. Jet, appreciate all your efforts in getting this done.
Thank you.
Yeah, it's very much appreciated. Okay, but before we close, I want to ask, well, any other questions or members of the board, or Katie or Anthony? Is there anyone from the public who's waiting to be heard this evening on Zoom in connection with the application of Huckleberry Lane East LLC? This is for property located at 11 Huckleberry Lane East in Hampton Bays. If you're waiting to be heard on Zoom, this would be the time to let us know by raising your hand.
No hands.
Okay, and Susan is yours.
Okay, so we're going to close the public hearing. We will accept written submissions up until November 5th with a decision on November 18th.
Second.
Ms. Kern,
Aye.
Mr. DeSessa,
Aye.
Mr. Kelly,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Chair votes aye. Thank you for being here, Chet. Have a good rest of your night.
Thank you.
Okay, we're going to move on to the decision calendar now.
Okay. I have a few to read, or unless someone else wants to go first.
I'll go if you want me to.
Sure.
Okay. So in the matter of the application of Greg and Michelle Favor, the subject premises is located at 6 Wells Lane, Hampton Bays. Property is identified in Suffolk County Tax Map as 900-321-4-7, is a 15,000 square foot property in an R40 zoning district. The subject consists of a single family 1-story home with masonry patio in the rear yard. This is a type 2 secret action. At the public hearing on the matter, Kevin Springer of Dynamic Legal Services appeared on behalf of the applicants. He described the property as a corner lot with 2 front yards and a very narrow depth of 100 feet, necessitating the partial location of the modest size pool in the front yard. The Zoning Board of Appeals finds in this instance the applicant has established it's entitled to the requested variance relief. It finds it meets the 5-part test as set forth in Town Code and New York State Town Law. So for the reasons set forth herein, this board grants applicant relief from the following provisions of the Town Code. 1, Section 330-11 Residential Districts Table of Dimensional Regulations for an accessory distance from street setback front yard of 51.33 feet, where 70 feet is required from the easterly property line, Wells Lane, for a proposed swimming pool. And 2, Section 330-76D, placement of accessory building structures and uses in all districts, and Section 330-83C, yards, to allow the proposed swimming pool to be located within the required front yard for the principal building. And 2, Section 330-11 for a principal front yard setback of 36.4 feet, where 40 feet is required, to legalize a roof over the front entrance constructed without benefit of building permit. This board also grants relief from Town Code 330-76D and Town Code 330-83C for the masonry patio located within the required minimum side yard of the principal building. These variances are granted for the structures as shown on the survey prepared by Howard M. Young, dated August 20th, 2021. The grant of the foregoing relief is subject to the conditions of such other permits as the applicant has heretofore acquired or may otherwise be necessary.
Second.
Ms. Kern,
Aye.
Mr. DeSessa,
Aye.
Mr. Kelly,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Chair votes aye. Anyone else? Or do you want me to start?
Can I do my second? Let me do my
Sure.
second.
Go
Yeah.
ahead. Why not?
In the matter of the application of Brian O'Sullivan, this subject premises is located at 32 Cove Road, North Sea, New York. Property is identified in Suffolk County Tax Map as 900-61-1-44, is a non-conforming lot of 25,188 square feet in R40 zoning district. This is a type 2 secret action. At the public hearing on the matter on this application, Carl A. Benicosta appeared on behalf of the applicant. He described that the undersized lot and location of the property on a corner with 3 front yards necessitated development of any significance requiring a substantial number of area variances. And Mr. O'Brien also testified. The Zoning Board of Appeals finds in this instance the applicant has established it's entitled to request a relief. It has met the 5-part test as set forth in Town Code and New York State Town Law. For the reasons set forth, this board grants relief from the following provisions of the Town Code. 1, for the proposed garage with porch addition to the existing dwelling on a non-conforming lot, Section 330-11 Residential Districts Table of Dimensional Regulations, for a principal front yard setback of 40 feet where 60 feet is required from the northerly property line Cove Road, and a principal front yard setback of 56.2 feet where 60 feet is required from the westerly property line Water's Edge Road. 2, for the proposed swimming pool. 1, Section 330-11 for an accessory side yard setback of 16 feet where 20 is required, an accessory distant from a street setback front yard of 58.4 feet where 70 feet is required from the westerly property line Water's Edge Road. And 3, Section 330-76D, placement of accessory buildings, structures, and uses in all districts. And Section 330-83C, yards, to allow the swimming pool to be located within the required minimum side yard for the principal building. And 3, for the proposed porch addition to the existing dwelling, Cove Road, Section 330-11 Residential Districts of Dimensional Regulations, for a principal front yard setback of 57.7 feet where 60 feet is required. And 4, to legalize a wood deck constructed on the south side of the dwelling without the benefit of a building permit. Section 330-11 for an accessory side yard setback of 4.3 feet where 20 feet is required, and Section 330-76D, placement of accessory building structures and uses in all districts, and Section 330-83C, yards, to allow the deck to remain within the required minimum side yard for the principal building. And 5, for the proposed second-story addition to the existing dwelling, Section 330-84D, pyramid height, for a proposed encroachment in the amount of 75 cubic feet. These variances are granted for structures as shown in the survey prepared by Stephen Beliski, last revised 9/15/21, and the plans and pyramid sketch prepared by Edward Armis, Hampton, Glass and Mira, dated 9/15/21, both incorporated herein. The grant of the foregoing relief is subject to the conditions of such other permits as the applicant has heretofore acquired and may otherwise be necessary for final approval of proposed construction.
Second.
Ms. Kern,
Aye.
Mr. DeSessa,
Aye.
Ms. Burgess, Mr. Daly,
Aye.
Mr. Kelly,
Aye.
chair votes aye. Anyone else? Where you want me to start?
Sure, I'll go ahead. The matter of the application of Matthew Cawley, property located at 50 Bullhead Lane in Bridgehampton, New York, tax map 988-1-17005. I'm going to read the request of relief at the end. At the public hearing held herein, the following facts were established through testimony and evidence. Testimony at the public hearing by Catherine Bowers-Craig of Kriegsman PC appeared on behalf of the applicant and testified that he wishes to renovate the existing home and construct a garage and needs a variance relief with respect to lot coverage. The percentage relief is the equivalent of 351 square feet and will not have an impact on the neighborhood. The renovation will include a new septic system, which will improve the environmental conditions of the neighborhood. Meets the 5-part test. Therefore, in the interest of justice and for the reasons set forth herein, the board grants Town Code 330-11 Residential District Table of Dimensional Regulations for a total lot coverage of 22.97%, where 20% is permitted for structures as shown in architectural renderings, architectural drawings, and site plan prepared by David H. Sherwood, architect, last revised September 30th, 2021. The granting of this relief is subject to the conditions of such other permits as the applicant has already acquired or may otherwise have to acquire for final approval of the structures on the subject premises.
Second.
Mr. Kelly,
Aye.
Mr. DeSessa,
Aye.
Mr. Daly,
Aye.
Ms. Burgess, Ms. Kern,
Aye.
chair votes aye.
You can start up. I have another one. Go ahead.
Okay. You want to do yours first, or I'll do mine
No, you go
first?
ahead.
Okay. All right. So I have 3 of them. The first is a decision on the application of Pheasant Walk Holdings LLC. This is for property located at Suffolk County Tax Map Number 900-134-55. This application is for property located at 47 Pheasant Walk, Hampton. Applicant requests variances to reestablish this non-conforming lot. This application passes the standards set forth in New York State Town Law and the Town Code. Therefore, this board grants relief from the following provisions of the Town Code to reestablish a non-conforming lot on a filed subdivision not continuously held in single and separate ownership. Town Code 33011, Residential Districts Table of Dimensional Regulations, as it relates to Town Code 292-44, exemptions waivers for a lot area of 59,006.37 square feet, where 60,000 square feet is required, and Town Code 33082, lot width, to allow a road frontage of 37.56 feet, and at the street line where a minimum of 40 feet is required, for a lot shown on the site plan prepared by Vincent Codiello, engineer dated May 3rd, 2021. Grant to the foregoing relief is subject to such other conditions and permits as applicant has already acquired or may otherwise have to require for final approval of the subject premises.
Second.
Ms. Kern,
Aye.
Ms. Burgess,
Aye.
Mr. Kelly,
Aye.
Mr. Daly,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye. Next determination I have is on the application of 1201 Noack Road LLC. This is for property located at Suffolk County Tax Map Number 942-351. This application is for property located at 18 Kendall's Lane, North Sea. Applicant requests variances for a covered porch, 1-story and 2-story addition to an existing dwelling and tennis court. This application passes the standards set forth in New York State Town Law and the Town Code. Therefore, this board grants relief from the following provisions of the Town Code. 1, for a proposed covered porch addition to an existing dwelling. 330-115C continuance for a principal front yard setback of 21.8 feet where 27.1 feet is existing. 2, for the proposed 1-story addition and 2-story addition to an existing dwelling. 1, 330-115C for a principal front yard setback of 23 feet where 27.1 feet is existing. And 2, Town Code 330-84D relief for encroachment in the amount of 40 cubic feet. And 3, for a proposed tennis court, relief from 33011 Residential Districts Table of Dimensional Regulations for an accessory distance from street setback front yard of 20 feet where 70 feet is required from the westerly property line, 40 feet right of way, Kendall's Lane. And 2, 330-76D, placement of accessory buildings, structures, and uses in all districts, and 330-83C yards to allow the tennis court to be located within the required front yard for the principal building. These variances are granted for structures as shown on the survey and pyramid sketch prepared by Squires, Holden, Weisenbacher, and Smith, last revised October 6, 2021, and the plans prepared by Edward Armas, PE, dated December 16, 2020. Grant to the foregoing relief is subject to such other conditions and permits as applicant has already acquired or may otherwise have to require for final approval of the subject premises, including submittal of an arborist report regarding the relocation of the beech tree to the Environmental Division prior to the issuance of a building permit, and securing any necessary approvals from the ARB for proposed fencing. This decision is also conditioned upon the installation and maintenance of 9-foot high evergreen trees as shown on the aforementioned survey by the applicant and all successors in interest in the premises.
Second.
Mr. Kelly.
Aye.
Mr. DeSessa.
Aye.
Mr. Daly.
Aye.
Ms. Burgess.
Aye.
Ms. Kern.
Aye.
Chair votes aye. And one more. This is a decision in the application of John Wisnicki and Charlene Quinlan for property located at Suffolk County Tax Map Number 986-233.1. This application is for property located at 116 Ocean Road, Hampton. Applicants request variances in order to convert an existing guest house into a carriage house. This application passes the standards set forth in New York State Town Law and the Town Code. Therefore, this board grants relief from the following provisions of the Town Code for the relocation, conversion, and expansion of an existing guest house into a carriage house. 1, Town Code 330-9D4C, density incentive provisions for a side yard setback of 20.7 feet where 30 feet is required for the proposed carriage house. And 2, Town Code 330-9D4 to waive the transfer of one or more development rights or PBC to the site. These variances are granted for structures as shown on the survey prepared by Lester Holden, LS of Squires Holden, Weisenbacher and Smith Surveyors, last revised August 9th, 2021, and the revised plans, sheets A0.00, A1.01, A1.02, and A2.02, prepared by Aaron Daly from Historical Concepts Architects, dated August 16, 2021, and letters dated September 15, 2021, and October 4th, 2021, for Elizabeth C. Dillon, Principal Historical Concepts. This decision is conditioned upon there being no further subdivision of the premises, so long as the carriage house exists without prior approval from this board and is subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of the subject premises.
Second.
Ms. Kern,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Mr. Kelly,
I am recused on this application.
and Mr. DeSessa.
I'm recused on this application.
Chair votes aye.
Application in the matter of, Adam, do you have more? Or was that,
Nope,
that was
that's
it?
it. That's it.
In the matter of Tom and Eva DeVito, 129 Shore Road, North Sea, New York, tax map 976-2, lot 16. I'll read the relief at the end. At the public hearing, Sean Barron of Barron Environmental, agent for the applicant, testified that the owners wish to construct a new two-story dwelling to replace the existing house. The new house will be further from the wetlands and will be accompanied by a sanitary system. Mr. Barron explained that the building department noted that the house is a three-story house and that as such requires relief from the board. Mr. Barron testified that there is no habitable space on the first floor, and the applicants indicated that they would agree to a condition as such. Meets the 5-part test. Therefore, in the interest of justice and for the reasons set forth herein, this board grants applicant relief from Town Code for the proposed three-story dwelling, 330-11 residential districts table of dimensional regulations for a proposed required rear lot setback of 20.3 where 30 feet is required. 2, 330-11 to allow the proposed dwelling to be 3 stories where a maximum of 2 stories is permitted. And 3, 330-84D pyramid height law for proposed encroachment in the amount of 1,621 cubic feet, 940 on the south side and 535 on the north side, 146 on the east side. These variances are granted for the structures as shown on structural architectural renderings made by Mark C. Matthews Architecture, PC, dated June 22nd, 2021, and the survey made by Raynor Marks in Carrington Surveying, last dated May 17th, 2021. The grant of the foregoing relief is conditioned upon there being no habitable space on the first story and is subject to the conditions of such other permits as the applicant has heretofore acquired or may otherwise be necessary.
Second.
Mr. Kelly,
Aye.
Ms. Kern,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye. I think we're done.
All right.
Yeah. Anyone want to make a motion to close?
Motion to close.
Motion to
Do
close.
do we have a second?
Second.
All in favor?
Aye.
Aye.
Chair closed. Thank you, Katie. Thank you, Charlie. And thank you,
you.
Ken.